In this video, we're going to be talking about the distinction between the institutional constructive trust and the remedial constructive trust. So there is an institution and remedy dichotomy. If it's institutional, so if you have an institutional constructive trust, there is a certain set of facts that make that constructive trust happen. So an institutional constructive trust arises at the moment the relevant conduct occurs. A remedial constructive trust, on the other hand, is where the court decides a constructive trust exists. So the remedial constructive trusts arises at the date of the judgment as a remedy awarded by the court to do justice in a particular case. The institutional approach is that it limits constructive trusts to defined sets of circumstances, and by doing so limits the judge's discretion in deciding when and how to adjust a person's beneficial entitlements. Under an institutional constructive trust, the trust arises by operation of law as from the date of the circumstances which give rise to it. The function of the court is merely to declare that such a trust has arisen in the past. The consequences that flow from such a trust having arisen are also determined by rules of law, not under a discretion. So that's from the Landesbank and Islington case, and that's what Lord Brown-Wilkinson said. So in this case, essentially what Wilkinson said is that the institutional approach is the correct way, is the more correct way. So this case says that with an institutional constructive trust, the property interest will attach from the date of the circumstances. Put another way, the court simply declares that said trust arose at that time, and the court doesn't exercise a discretion about the trust's existence. So from the same case, Brown-Wilkinson said that a remedial constructive trust, as I understand it, is different. It is a judicial remedy giving rise to an enforceable equitable obligation, the extent of which it operates retrospectively to the prejudice of third parties lies in the discretion of the court. So Lord Brown-Wilkinson continues here by saying that with the remedial constructive trusts, there is no formula to be applied. In such circumstances, the court would just be looking at the situation and say whether or not it is unfair or unjust. So with a remedial constructive trust, the court would say that in the interest of fairness, they will, at their discretion, award a judicial remedy giving rise to an enforceable equitable obligation. Now, unfortunately, it's not quite resolved as to which approach the institutional or the remedial constructive trust approach is the one that should be taken. Okay, there's a little bit of uncertainty as to which approach the court should and has taken. Okay, the English courts have always been cautious in awarding proprietary remedies, whether as resulting of proprietary trusts, where the award is retrospective or affects the property rights of third parties. So most common law countries use the remedial approach. For example, Australia uses the remedial constructive trust approach. The English courts have started off, or did start off, very institutional, so they were very restrictive or very cautious in their approach. So they could only really see a constructive trust where there had been some sort of fiduciary breach. Now, during the 1970s, the United Kingdom's Court of Appeal, led by Lord Denning, adopted a free-ranging remedial basis for constructive trusts and came to the view that a constructive trust is imposed by law whenever justice and good conscience require it. So Denning came up with a new model, insisting that the court need not be so restrictive or formulaic. He viewed constructive trusts as imposed by law whenever justice and good conscience require it. So he was definitely embracing this Cardozo approach that I talked about in the previous video. In other words, looking at conscience and equity. Now, later English decisions rejected the new model of constructive trusts, and we can see that from the case of Lloyds Bank and Russet. So later, the court said that they need predictability and needed to take a formulaic approach. Put another way, the court didn't think you could have this free-flowing concept. So in this particular case, Lloyds Bank and Russet, the court rejected this new model of remedial trusts that Denning had advocated in 1972. Okay. We must recognise that the remedial constructive trust gives the court a discretion to vary proprietary rights. You cannot grant a proprietary right to A who has not had one beforehand without taking some proprietary right away from B. No English court has ever had the power to do that except with the authority of Parliament. So in this case, Norse says that Denning was going way beyond the scope of judicial power, and he said we cannot be so ready to pull proprietary rights from individuals. Okay, so it's still a bit uncertain as to which approach they take, but this led us all the way to the court of FHR European Ventures and Cedar Capital Partners. So I've kind of laid out exactly the case facts here, so I'll go through them now. In December 2004, FHR European Ventures LLP purchased the issued share capital of Monte Carlo Grand Hotel for €211.5 million. Cedar Capital Partners provided consultancy services to the hotel industry and had acted as the FHR's agent in negotiating the purchase. In September 2004, Cedar had also entered into an agreement with the vendor, which provided for the payment to Cedar of a €10 million fee following a successful conclusion of the sale and purchase of the issued share capital of Monte Carlo Grand Hotel. The vendor paid Cedar €10 million in January 2005. Okay. In November 2009, the claimant commenced an action for recovery of the sum of €10 million from Cedar and other parties, claiming that because Cedar owed a fiduciary duty, it was not allowed to make a secret commission. Accordingly, FHR claimed that all profits were held on a constructive trust. Now, this whole case, the facts of this case can be pretty tricky to get your head around, but essentially, FHR purchased shares from Monte Carlo Grand Hotel. Cedar provided agency services, and as we have an agent here, there exists a fiduciary duty. FHR said that they were the rightful owners of the fee, so claimed the money was held on a constructive trust. Okay, the Supreme Court dismissed the appeal and held that Cedar Capital Partners held the €10 million commission on constructive trust for FHR. Lord Neuberger gave the leading judgment with which the whole court agreed. So, Lord Neuberger agreed a constructive trust did exist on this fee. And he goes on to talk about the differences between the institutional and the remedial constructive trust, which is why this case is important to us here. And essentially, Neuberger says that this was a very formulaic case, and he dismisses the remedial approach. And it was formulaic because there existed a fiduciary duty, and you cannot profit from your fiduciary duty, as I have mentioned in previous videos when talking about fiduciaries. Therefore, there has to be a constructive trust. The court was simply following that formula. Now, if you want to watch the full judgment on this case, I will put a link in the description below. And Lord Neuberger really does address a lot of the issues of constructive trust, so it is worth checking it out. So, the final question then really is the matter settled? So does the case of FHR and Cedar Capital Partners say the argument is over and institutional constructive trust is the way to go in the English courts? The answer is we're going to have to see, okay? The case was a classic case. We'll have to wait and see for some non-classic case before we can say that the issue is settled. But extrajudicially, Lord Neuberger has said that the remedial constructive trust represents an unnecessary weapon in the judiciary's armoury, a book too many in equity's library, and a discretion to too many in a chancery's judge's locker. Okay, so to him, I guess the issue is resolved. So that's about it. I mean, we still don't know the answer to this, and it's up to you, I guess, to have a little think about what approach you think is best, have a look at what other countries are doing, and what you think is the best approach for the English courts, and what could be the approach by the English court in future cases. So do keep an eye out to see how the court does approach the institutional and the remedial constructive trust in the future. But as always, if there are any questions at all, then please make sure you leave a comment below and I'll get straight back to you. If you enjoyed the video, then make sure you give it a thumbs up and subscribe to my channel. Thank you very much for watching.